My name is Bruce Dearling. I'm a partner at Hepworth Browne and a European patent attorney and chartered patent agent. I'm responsible for the emotional perception case in the UK, and that seems to have some fairly broad national and international applications. So you're listening now to IP Fridays.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
My co-host Ken Suzan and I are welcoming you to episode 175 of our podcast IP Fridays. Today's interview guest is Bruce Dearling, patent attorney and partner at Hepworth Browne in the UK, and we talk about how non-technical features must be considered when assessing inventive step of patents, at least according to recent decisions of the UK Supreme Court and the Unified Patent Court. But before we jump into this very interesting interview, I have news for you. On May 20th, the Swiss Federal Council adopted the fully revised patent ordinance, which will enter into force on 1st of January 2027, together with the revised Patent Act. In the future, the Swiss Federal Institute of Intellectual Property will prepare a mandatory search report for each application. Applicants can choose between a partially examined version and a full examination that assesses novelty and inventive step. The full examination costs an additional 300 Swiss francs, and renewal fees will increase by a total of 8% over the 20-year term. On May 19th, Asus entered into a licensing agreement with the Wi-Fi multimode patent pool managed by Sisvel, thereby ending all ongoing infringement proceedings. Sisvel bundles standard essential patents in the pool from, among others, Atlantia, ETRI, and Mitsubishi Electric. On May 18, the UPC Local Chamber in Düsseldorf rejected Align Technologies' application for a preliminary injunction against its Chinese competitor Angelalign. Angelalign may continue to sell its clear aligners with the UPC jurisdiction. Our partners Dirk Schulz and Ulrich Storz and Wanze Zhang, together with Arnold Ruess, successfully represented Angelalign. The US Patent and Trademark Office announced this month since October of last year it has invalidated or is seeking to invalidate approximately 10,500 trademark applications or registrations in 11 administrative orders. Reasons include forged attorney signatures and the fabrication of non-existent filing requirements. This stems from ongoing abuse of the US trademark system, primarily by non-US applicants, which can lead to conflicts with validly registered trademarks for legitimate businesses. On May 12, the British Court of Appeal overturned a lower court decision that would have required Nokia to grant interim licenses for video coding patents. The court found that Nokia's license offer to Taiwanese manufacturer Asus and Asus had already been made on RAND terms. In May, the US Department of Justice filed a brief on the ongoing Corteva versus ETRI litigation, expressing antitrust concerns regarding certain patent practices in the field of plant breeding. This marks the first time the agency has actively intervened in a biopharmaceutical patent dispute with implications for seed innovations. And now let's jump into the interview with Bruce Dearling. Today's interview guest on our IP Fridays podcast is Bruce Dearling. He is in the IP field and patent attorney for 36 years and partner at Hepworth Browne in the UK. Thank you very much for being on the podcast.
My pleasure, Rolf. Thank you for inviting me.
All right. We just met at the INTA annual meeting in London, and you talked about the UK Supreme Court case where you were involved. And the core questions were whether non-technical features would be considered when assessing inventive step of patents. Can you briefly summarize this case?
It's a bit more than that. It started, I I actually wrote the case and I prosecuted it through the UK through the Patent Office. The Patent Office rejected the case for being excluded subject matter. So pretty much the excluded subject matter provisions in the UK are meant to be identical. They're as near as practical is what the language of the Act says. So those are the European Patent Office. So Article 52.2. But they apply as such. Now the actual technology relates to artificial neural networks, and the invention related to a very clever way of what they term closing the semantic gap at the output of a neural network. So that means that a neural network, there's always a discrepancy between the output of a neural network in terms of what it's telling you you should be thinking, essentially, and what reality is. So if you can close the semantic gap, then you align the neural network and the artificial intelligence system to better reflect human knowledge or human reactions and human expectations. So that's really what the invention is about, and there's no point in going to too much detail with it. It's just that's the way it is. It's very clever. So the UK IPO rejected this because they said it was essentially a computer program or excluded from patentability as such, and they used a decision which is called Airtel, which has been around since 2006, and that decision has caused considerable consternation and anxieties between the EPO technical boards of appeal and the UK courts. Airtel was described as being essentially disingenuous by the EPO technical board of appeal, and the UK courts pushed back and said, you don't know what you're talking about. So that's where it fell apart. So that's where they rejected it for essentially being a computer program as such, possibly with a bit of business method thrown in as well. But let's leave that for the time being. So the case then went to the High Court, and the High Court, we won. The judge said, actually, it's not a computer program. Neural networks aren't computers. They're not programs themselves. There's more to them. They're not. And the invention, as claimed, is not excluded from patentability as such. The UK IPO obviously weren't very happy about that, because they liked their Airtel case, and they appealed it, and they appealed it on it being a ground on several grounds, including a new one, which was a mathematical method. The Court of Appeal decided that the UK IPO was right and that we were wrong, so we lost the case. So we then went to the Supreme Court. Well, actually, they denied us an ability to go to the Supreme Court. The court said no appeal. We went, actually, no, I think this is a bigger issue here, because we realized, or I realized at that point, that the work that we were doing was much broader than this. It requires real consideration of what an invention is at a fundamental level. So not only exclusions, but how inventive step is applied. So these issues were built into the case from the very beginning, and they sort of, I wouldn't say crept up on the courts as we went through, but they became more and more prominent to the extent that ultimately, when we made an application to the Supreme Court went, yep, we've got some issues here. We want to hear the full decision, or the full arguments on why this is not excluded from patentability, why Airtel is potentially bad, and how we more or less try and align ourselves with the European Patent Office, more or less. So that's essentially what happened. And the hearing was the Supreme Court decision, or the hearing was last July. It took them the thick end of 8 months to come out with a decision, which was issued in early February, at which point the entire legal landscape in the UK changed, because they said we were right, Patent Office don't know what they're talking about. Airtel is bad, it's unsound. That's what they described it as. It's unsound law. It needs to be removed, and we're going to harmonise with the UK, with the European Patent Office. So before I suppose I'm just going on a rant here, I suppose, or standing in my soapbox, telling you what you already know. But the Aerotel test essentially was it's a 4-step test, or was a 4-step test, past tense. So you firstly had to construe the claim. That's pretty straightforward. Then you actually had to identify the actual contribution. This is what they said: identify the contribution. Really, in this aspect, you're asking what, as a matter of substance rather than form, the inventor has added to human knowledge. So that's what they said that contribution was. And then they said the next step in Aerotel was to say, well, does that contribution fall solely within the excluded subject matter field or the realm? And then they said, well, if you get through that question, then you check the actual contribution or the alleged contribution to see whether it's technical in nature. So that's the Aerotel test as it was. And what the Supreme Court in their unanimous 5-0 decision was that Aerotel at best jumbles up the order. It reverses the logical order of the analysis by starting with the contribution to the known art, then addresses the Article 52 exclusions, 52 and 3 exclusions, and then finally goes back to what the technical nature of the invention is about. So they really went, no, we don't like any of this stuff. It's bad, it's stupid, it's putting the cart before the horse. So in the intervening period between filing the case and actually seeing it progress all the way to the Supreme Court, we obviously had the G119 decision from the EPO enlarged board, and they basically said that we are going to validate any hardware as the approach. And that's essentially what the UK Supreme Court said. We're going to validate. We're going to say that the threshold of patentability or the exclusions to patentability are simply overcome by the inclusion in a claim of any piece of hardware, whether it's a processor or a piece of memory or whatever. It doesn't matter. Any hardware makes the invention a technical invention. So it's a really low threshold to consider. And they then went, well, actually, if we now align them and harmonize with the European Patent Office sensibly, then we need to look at how we assess inventive step, which is the other thing that we then raised with the Supreme Court. In fact, we probably raised it at other times in all the other instances as well, but it came to its head as the Supreme Court. So the Supreme Court then also went a bit further and said, well, actually, whilst we do like the approach in our global approach to assessing inventive step for all fields of technology, whether it's chemistry or biotech or electronics or software or AI, we use a test called Pozzoli. So that isn't problem solution. We don't like problem solution. We think it's not codified in the European Patent Office. It's just a mechanism that the EPO has come up with to try to objectively assess inventive step. We don't particularly think that's appropriate. We like our approach called Pozzoli. That's it. So we're going to stay with Pozzoli. However, in order to actually understand, particularly in the context of mixed inventions having technical and non-technical features, it's necessary for the examiner to undertake the so-called intermediate step, where you have to look at the interactions between features within a claim. The invention is defined by the claim. That's what the Act says. That's what everyone understands it to be. The invention is defined by the claim. So you look at the claim features, and then you have to understand the interactions which go about, which take place. And even if they are between technical and non-technical features, so long as they bring about an overall technical effect when you consider the invention as a whole, then your claim should be good, and you can assess it for classical inventive step. So that's really where we're at. So there's a lot to unpack there already. It's probably a podcast in its own right, but that's the potted history of where we're at. So, and I can probably say that if I go on, I can keep going if you wish me to for a second and talk about why I think this is. We'll just contrast it quickly with the problem solution approach at the EPO and CONVIP. So for technical inventions, we look at inventions in the computer implemented field. We use CONVIC, or they use CONVIC and the problem solution. The Supreme Court said, as I said, they don't like problem solution. I think the problem solution issue is it is also inherently pre-baked with hindsight, because you have to look at the invention and then step back and exclude those features which are common, and then you formulate a problem based on the function that you're trying to achieve by the claim, or that the claim achieves, and then you're setting that problem up as whether or not it would be obvious for a skilled person to arrive at the claimed invention, having by providing a solution to that hindsight developed problem. So CONVIC is not great by any means. And we know from a practical perspective that examiners are only too willing to look at a claim and simply line through features which they believe are non-technical, whereas they don't actually look at the interaction of those features in the context of the claim as a whole. There's actually a decision, very recent one actually. Was it about a year, probably a year ago, T1249/22, where the Technical Board of Appeal slaps the examining division with, you cannot do this. It's okay to have a claim directed towards an invention in a non-technical field, as long as the invention is directed to a technical solution of that problem. I think it's paragraphs 11 and 12, or 10 and 11 of that decision that are worth looking at. But they're saying that you know, in all fields of technology, it doesn't matter as long as it's a technical solution. Patents are about technology, therefore you should be able to obtain this as long as there is a realistic and appropriate technical contribution. Well, be careful actually, Bruce. I don't mean technical contribution, I mean technical effect. And there's a reason.
The technical features are the non-technical features are nevertheless used to assess inventive step in the UK now after this decision, right?
Yes, that is the intermediate step. You have to look at the reason is the decision says you must look at the invention as a whole. It's the important thing. You have to, there are a couple of issues that arise out of this. The first one is that you have to provide context for the invention. The Supreme Court never provided any guidance about how we deal with the intermediate step, or what the exact test is, which is in some respects fine. It seems to be fairly clear that you have, it just means that you actually have to engage your grey matter, your neurons, to work out what is going on in the real world. And once you work out what's going on in the real world, what the benefits are, then you look at whether or not the actual implementation of the invention fundamentally has a technical flavor to it, which is not just coding, not just simple coding, but it does something smarter. There's a real technical impetus. There's a technical effect. Now that actually that brings me on to something I've postulated or I've said. I think the intermediate step will follow something that I've termed the holistic character test, which essentially is work out what's going on in the real world. Then once you've worked out what's actually being achieved, what the benefits are, what the invention's concerned with, then you ask the question, how am I achieving it technically, and how is there a technical effect? How does the technical effect arise? Now, that is a really interesting, that brings out a couple of issues. The first one is that it's actually about the word contribution, because it depends on how the word is used. So if you look at the head note 1 in CONVIC, it says the word they use to contribute, or how the non-technical feature contributes to the invention. So that's an additive, inclusive concept. The UK IPO historically, and arguably at the moment today, whilst they're trying to retrain their 400 examiners that this case has caused them to have to do, their idea of contribution is this backward-looking concept. So technical contribution and technical effect, I think, although we mix them up and we interchangeably use technical effect and technical contribution, they are distinct. Technical contribution, actually, you're looking backwards. Technical effect is causal. You look forward into what's going on. So it's really subtle, but it's important. And once you realize that you are actually looking for the technical effect, then you're on much safer ground. It's much more objective in terms of the assessment that one undertakes to determine patentability. Again, this might be somewhat contentious because it's the way I'm looking at this. But I've been working on this a long time and thinking about it for probably decades.
Right.
Worryingly so. So it's just that technical contribution, technical effect, probably not the same. Well, they are interchangeably used to mean the same thing, but they are not.
And in the beginning, you said now that Aerotel is dead, basically, it's more harmonized with the EPO's approach. But what I take from the discussion now is that maybe, especially in view of the problem solution approach, it's not harmonized with the EPO's approach at the moment, right? Or did the UK Supreme Court get something wrong, or was that a desired outcome from your point of view, that this is not so completely harmonized with the EPO at the moment?
Well, the EPO, any hardware solution is fully harmonized, no doubt. So it's now a question of inventive step. So Article 56 or Section 3 of the Act. So the EPO does not mandate, or the EPC, nowhere does it mandate the use of the problem solution. And we know that there are many different ways of actually assessing inventive step, including the concrete elaboration test from last year and problem of invention. So there are numerous ways of assessing inventive step. So the UK says Pozzoli, we like Pozzoli. Interestingly, I had a discussion with someone I probably can't mention. They're saying that the UK approach may actually be more permissive now, might even influence how the EPO operates. So they may move away from convict towards a more, this Pozzoli approach, which basically says that you identify the notional skilled person, step 1. You identify the common general knowledge of that skilled person, step 1B. You identify the inventive concept of the claim in question, or you construe it if you can't work out what it is. You then identify what the differences are, and then you ask the question, is it obvious to the skilled person, given the knowledge of the general part and the prior art? This is entirely not artificial, because, as I said beforehand, if you look at problem solution, you are formulating a problem by backtracking from what the claimed invention is to a situation where you say, well, these are the common features, and I'm going to project a problem to try and solve. Now, that is already tainted with hindsight reasoning. It's not safe. It's not thoroughly objective. There is a problem. There is an inherent problem with this, which sees inventions, good inventions, cast by the wayside. So it's not, although it's a preferred mechanism, it's not fully baked. There are situations where examiners are inherently lazy, or they just simply, they use something like the requirement specification argument, or something like this, which is just fatuous. It doesn't, it just demonstrates that they can't be bothered to actually argue it properly or think what the invention is. That may be a bit, sorry to any examiners that's listening to this, but this is just my objective, my personal view, that sometimes there are problems. I'm reminded of a quote from an EP at a hearing I was at a long time ago, and the legal board of appeal member said, we understand that examining divisions can operate with a degree of mental laziness and that it's too easy to throw too many things out of the basket when considering the issues of inventive step, unquote. Now that one sat with me because it was actually, you think, did someone just say that? And the answer is yes, they did. But it just goes to show that there is some tension between the TBA and the examining divisions, that they don't always get it right, as we know.
Yeah.
So
there might be a small difference now between the UK IPO's future approach of assessing inventive step and the EPO.
Yeah,
but
it might
let's
do.
see.
Yeah, it might do. But I mean, the other interesting thing here, and it, thank you for pointing this out. I hadn't entirely caught up with I've been traveling beforehand, but I missed some of the UPC case law. So the UPC case law in
we talked about that. There was a decision in April, Abbott versus Sinocare.
Yeah, 901 of 2025. So Court of Appeal decision from the UPC, which basically says 0000901/2025. So decision 17th of April, hearing 27th of March. The UPC is not bound by it's a court. The European Patent Office is not a court; it's an agency who look after the administrative rule of law. So the fact these decisions come out from the UK Supreme Court in February, and you see almost identical language used in the UPC decision, suggests that there is some alignment here, or there is some convergence in thought. Now, whilst the UPC decision also references G119, it uses problem solution. There is enough, you've got to bear in mind that one court will, the high level courts do look at each other's decisions. And this is really a question of influence and the desire to converge. So the fact that they've done this at this time is quite interesting. Again, I can't quote someone directly from the EPO, although I would love to. They were just to say that they are a high level, at a very high level, and they use the words converge UK practice or UPC practice towards EPO converge UPC practice towards UK Supreme Court practice on interpretation of the law. So we may actually be seeing it in real time, this going ahead. Again, I can't, it would be wrong of me to actually refer to anyone, but it's just, it's an observation that when I looked at the case, I can see why this is going ahead. And I can see why the judiciaries don't they want to maintain independent judicial control, so they won't reference a UK Supreme Court decision, not least because we're not in the UPC. But if you look at the arguments in sections 106 and 107 of the UK Supreme Court emotional perception decision and Headnote 1, you go, wow, this is very close.
Very close and nearly identical wording.
Yeah.
And
looks like they can almost
UPC also, the UPC also now uses non-technical features for assessing inventive step. Is that a problem for the EPO that has been historically been aggressive in throwing out non-technical features for inventive step analysis?
Well, I think, as I said, I think they really need to get to the situation. That's this holistic character test that I'm sort of proposing, where you really have to think about what the invention is achieving, and then look at how it's technically being achieved. And then if you look at that again within the context of that other decision, the one that I mentioned, the 1249/22, it says something like, in the case of an invention that amounts to a technical implementation of a non-technical method, provided the non-technical method does not contribute to the provided it does not contribute to the technical character of the invention, the board validated the approach to identify on one hand the non-technical method, and then basically goes through and says it's patentable. you can, there are decisions like this which suggest that you've got to give it a bit more, that the examining divisions have to give it a bit more thought, because the Technical Board of Appeal realised that to satisfy the WTO requirements, which we're all bound by, or pretty much everyone's bound by, Article 27.1 TRIPS, that you protect all fields of technology, and that means you have, whether it's data processing or business even, because business methods can be patentable so long as they are implemented on a technical basis. That essentially seems to be what the 1249/22 case is essentially saying, although it doesn't say allowing business methods. The exclusions only bite as such. So does this open, does this decision in combination with the Supreme Court case, in combination with the movement of the UPC, say, well, actually, let's look at this properly. It requires objective assessment, not just superficial, let's strike through that feature because I don't like it, it looks non-technical.
So are you hopeful that the EPO is adjusting and will reshape their case law in view of the UPC decision and the UK Supreme Court decision?
It's a bit unfortunate that the corresponding UK case was dropped by the applicants, because it was going to have an examination. There was going to be a hearing of it at the examining division, and it would have gone to the TBA, and I'm sure it would have then gone from the TBA to the EBA. Pretty sure that that's the case. There is another case from the client which will probably argue the same thing, because the specs are almost identical. It's just lagged in time. So is it going to change? I hope so, because I think the EPO have got it wrong more often than not in this field. Well, maybe not more often as long as they get it wrong occasionally, more times than they should do. So would I like to see it to be changed? Yes, I would, because I want the examiners to actually think about the technology as opposed to just, oh, it's not, I don't want to engage the grey matter. It's too much effort. That serves no one. That doesn't serve technology. That doesn't serve industry. These things are there for a reason. These patent rights are there. They are personal. They are property rights. Referring to the decision, or the award of the 2025 Nobel Prize for Economics, they are a core driver for society's development. The 2025 Nobel Prize was for something called creative destruction. You're probably aware of that. So that's the replacement of old technology with new, and it's based on the patent paradigm. So it's really, all this stuff is coming to a head now. It's just a question of how quickly the EPO actually catch up and provide. Maybe if they have, so they need to catch up. Maybe they do. It's just understanding that you've got, the examiners have to start to think. I mean, as I said, we've got the issues at the UK IPO where they're going to have to retrain 400 examiners.
Yeah, right.
So and they're watching the. I've just sent the case wasn't actually, the emotional perception case wasn't granted by the Supreme Court. They referred it back to the Patent Office for consideration under an intermediate step. So the Patent Office dished out a load of rubbish, or I would say arguably a load of rubbish, which I filed the response to, which basically says you don't really know what you're talking about. Really worries me a bit, because the issue that I think they think that they're trying to introduce the Airtel case through the back door. It's backsliding. It's a mechanism for trying to apply it in a different way or a different context, which would be wrong. I think that they believe that the applicant will appeal this. If they get a bad decision, they will appeal it back through the courts again. So that's the High Court, Court of Appeal, Supreme Court route. I say maybe not. I say maybe the client will file what they call a judicial review, which is a nuclear option. That's when you actually hold the Comptroller General of Patents to account and get full discovery of whether or not there's internal documentation showing that they are deliberately circumventing the direction of the Supreme Court on the intermediate step. So this is basically holding them to account, saying if you're not applying intermediate step appropriately, you are in contempt of the law. So judicial review is a really nasty thing to do, but it's certainly something I would not exclude from consideration. We'll see what happens, but it's a really nasty thing to do, because it's not saying we're just going to go through the courts and make them a decision and let them decide on this. We're going to say you're wrong, and there's enough indication that there's already enough evidence in the file to suggest that they are in contempt. They are probably in contempt of court, and they're not applying the intermediate step appropriately. They don't know any better at the moment. They need to be guided, but the consequences for them are potentially severe.
I have another question for you. You were the instructing attorney, and do you think the decision was perfect? What was the argument that you made was the most underappreciated argument by the court, and where do you think the judgment got it wrong, or was it all perfect?
No, it got 90% or 95% it correct. So the intermediate step is right. That's the most important thing of the decision. It's the intermediate step. The any hardware thing, that's logical, that makes some sense. So people will say it's the any hardware thing. No, it isn't. It's the intermediate step that's the important thing. Where do they go wrong? I think they went wrong because you've got to bear in mind that, unlike German courts, I'm going to be careful here about how I express this. Generally, as I understand it, and correct me if I'm wrong, but the judiciary in Germany on the patent cases generally are more technically able. They're normally technically qualified. Now, I look at the Supreme Court justices and the Court of Appeal justices, and we had the Court of Appeal justices. One was a metallurgist undergrad. One was a chemist. Good luck with trying to argue complex artificial neural network technologies, which are difficult even for me to understand. I've been working in the field at one. They're hard to understand. They require real appreciation. So they could say, well, actually, we don't need to look at the technology. But frankly, if you're looking at statute and exclusions to patentability and what a computer program is, then you need to understand what these technical terms really are. And if you can't, then you're going to do the judgment is potentially flawed. So they're finding that the neural network is a computer program is obtuse, I think, technically. I know that the Singaporean government, the Intellectual Property Office of Singapore, released about 6 weeks ago a consultation note to the sovereign, for sovereign review of to its professional, the Singaporean population, saying, is the emotional perception case right, and do we need to adopt it into Singaporean national law? So this is direct soft power from the UK Supreme Court changing Commonwealth legislation statutes. We'll see what happens, but from what I see I've seen a draft from the response from the attorneys, and they're saying essentially we agree any hardware is right, the intermediate step is right, the assessment that a neural network is a computer program is wrong, or it just doesn't make any sense. And I've made the same comments before in CEPA, in the article I wrote in March. There's a disconnect. I mean, it's like they equate a computer program with being able to be run on an analog computer. Now, an analog computer has no central processing unit. So an analog computer just has resistors and transistors and whatever, and capacitors. So if they're saying that an analog computer can run a program, that's essentially what they're saying in part of the judgment. Where is the program in an analog computer? I really, if they're saying it's in the values of the resistors and the capacitors, then that has implications for any circuit that we've got that's potentially a computer program, which is just madness, because then that doesn't sit well with decisions that we've been, or the legislation which and decisions that we've looked at over the last 50 years. this is a real problem. This is it may be a storm in a teacup because you can overcome the objections by having any hardware, but it's an argument they shouldn't have been making. It seems to be abstracted legal argument, which has little credibility in my personal view, although it's now law. I can't. It may be that someone can take that up and argue it with the Supreme Court, get them to fix this, get the EPO to turn around and say you're wrong. I mean, that's the other thing is the EPO look at this as a mathematical neural network as a mathematical method, and the UK now said it's a computer program. Neither are right. The EPO is wrong as well. If you look at the actual decision which they regularly quote, which is the Mitsubishi case, if you actually read the claim and look at the case, you've seen that it doesn't make a huge amount of sense. This is applied, and a neural network has applied mathematics in it. It can be based on a computer program because it's required to set up the learning objectives and the loss function. The mathematical process it tweaks the weighting factor of neurons over the course of the training epochs. But at the end of the day, if the function performed by the neural network is new, it solves it. It's directed towards a technical implementation, which is technically relevant. Then it shouldn't be excluded from being a mathematical method. I think the guidelines actually say that it's not. Even recommendation is. The UK court said that recommendation is not technical. Well, actually, it is, because it's data processing, and you've got to work out how does the data processing work to provide an improved recommendation. Again, it goes back to the 1249/22T decision. So there's a whole raft of these things which are left to be not entirely resolved. There's enough in here to keep someone busy for a few more years.
Right. So I have a question to you now that we talked about the decision of the UK Supreme Court and the UPC, the Unified Patent Court, with a very, very, very similar wording. What do you say are the three most important takeaways for patent practitioners in the US, in Europe, in the UK, before the EPO? Are there any things that you really want patent practitioners to take away from our discussion here?
Yeah. Okay. So make sure the claim has some structure in it. So you need to have any hardware. So that's number one. So it's a processor. Make sure that I think that's just in terms of plain draft. In terms of the description, you really got to understand what the invention is about, and you've got to make sure that you explain what function is achieved by what piece of hardware, or kit, or software. And if you do that, if you nickel and dime this by writing the claim first, I would suggest that you run into problems. You need to understand what the invention is about, and you need to make sure that the description is complete and full to describe the functionality and the effects that are achieved in the real world. And if you can do that, then you're on a much sounder basis, much stronger. There's a much stronger foundation to this. So I think that's two things. Is there a third one? Send me the word. No, it's just that's me being cheeky. But I suppose I know what's going on. Well,
but maybe the third takeaway is that maybe the EPO will maybe rethink the way, at least how AI inventions are assessed for inventive step.
Well, as I said to you before, it could be that that's the case. I don't want to break that again. I can't. The word permissive was used in a conversation I had with respect to the UK Supreme Court approach in Pizzoli. I don't believe, convict fundamentally still grates with me, and it has done for years, because the way it's set up and the way it's applied distorts fundamentally what the invention's about. And until such time as that distortion is removed, then there is a problem of objectivity versus subjectivity. And I think that's really what the EPO have to, they have to grapple with this. It's not an easy thing to deal with, but maybe there are things going on. It depends on what I don't know who's going to argue. I mean, as I said, it would have been useful for me to still have the original case up and running at the EPO, because these arguments would have been fleshed out, and I'm pretty sure they would have been referred to the enlarged board. We would have got it resolved. So it's whether or not I can now work this into the existing case to try and get the division to, well, they will refuse it, I suspect, and then it'll go to the TBA, and then the TBA will then have to look at this, hopefully with the referral to the enlarged board, and then that fixes the problem on a national and international basis.
Yeah. Let's see.
So we don't know. I mean, you might have a different view. I mean, what do you think? Do you think that do you think Convic is fundamentally right or fundamentally wrong?
Well, I'm not so much into AI inventions. I'm a chemist, and I usually deal with chemistry inventions. But from the discussion that we had, I think that the EPO might rethink their position. I don't know. Let's see. Yeah, let's hope so.
Well, you never know. I mean, so they like they like the problem solution. It's been with us for 25 years.
Right.
It's just that it's a compromise. It's not mandated by the European Patent Convention. That's the point. It's something they think works, and these things only work until such time as someone comes along and says, actually, you're wrong, and this is the reason.
Let's see if they choose a different route for at least for AI inventions. So, Bruce, thank you very much for your insight and for talking about the case that you were involved in with the UK Supreme Court. Where could people reach you if they have more questions about this field, basically patents, AI protection in the UK, in Europe, and if they want to ask you more questions about this case?
Sure. I mean, it's my through my through the Hepworth Browne website, or my LinkedIn profile, I suppose. I mean, the Hepworth Browne website has an email link. It has some questions. I mean, I'm trying to post things on it as well to try and provide a bit more context. But it's if people have if there are fundamental questions that they have on this stuff, then I'm happy to try and answer them. I mean, I suppose that I can be considered to be quite knowledgeable in the area.
Right. Certainly more than I am.
So I was fortunate. I mean, I think this, as a consequence of the work I've been doing, I was appointed last year to WIPO's standing committee on patentability, where this was discussed, or the issues of where WIPO goes, and what the direction of the problems are that we have in high tech areas. So there seems to be some degree of understanding that I might know what I'm talking about. I think I probably do, but
yeah. Thank you, Bruce. Thank you very much for being on IP Fridays.
My pleasure. Thank you very much, Rolf, for inviting me. I hope it's been informative.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.